Hey everybody, I've got to do this pretty quickly. I have an active volcano behind me uh, and a dog in front of me. Uh, is um, testing my face, but things are, going a little bit crazy here. So you can see there's oil flying up to the side there. So I thought I would talk today real quickly about uh, the selective incorporation of the Bill of Rights and in regards to criminal procedure. And it's important to note that when they first passed the Bill of Rights in 1791, the question really came up early on, who does the Bill of Rights apply to? Is it designed to limit the national government from infringing your rights, or is it designed to limit the state government from infringing your rights, or is it designed to limit both? And that's the case that came up in the Supreme Court case of Barron versus Baltimore. Now, in Barron versus Baltimore, Barron owned a wharf in Baltimore, and Baltimore had done some excavation, and I thought I saw a dinosaur over there. I'm back 500 years BC thanks to my time traveling computer. And what they had done is they had made Barron's wharf, where he made his money, he allowed ships to dock there and unload into his warehouse, too shallow for the ships. And so he'd been deprived of his property. And so he decides, because he's a good American, to sue. And that's what all good Americans do, is they sue. Well, it goes before the Supreme Court and the greatest Chief Justice of all time, John Marshall, and Barron wants $5,000, but Marshall rules that the Bill of Rights was only intended to apply to the national government, not states. States have their own bills of rights, and so Marshall's ruling here is a very narrow ruling, saying that the Bill of Rights only affects the national government. The states could do what they wanted to do. Well, that's going to continue for a while. And after the Civil War, there was some concern among Northerners that freedmen were not getting their rights respected. And Southerners had argued that, well, because they're not citizens and we don't have to give them the rights. Now, there were Northerners that were, genuinely concerned about the plight of freedmen, freed African American slaves, and wanted something positive done about it. And then there were the other Northerners who felt that, hey, if we don't do something, they will eventually move north. And some of these Northerners were just as racist as Southerners. And so what they did was they got past the 14th Amendment. Now, the 14th Amendment says all persons born in the United States or in the jurisdiction thereof are citizens of the United States in the state wherein they reside. In other words, if you're born in America, you're a citizen. We've talked about this. And not only are you a citizen of the United States, you're a citizen of your state. And it goes on to say that nor shall any state deprive any person of life, liberty, or property without the due process of law, nor deny any person the equal protection of the laws, and establish the same privilege and immunities of citizens of the other states. In other words, the general idea behind this was to try to get the Bill of Rights applied to the states, some protection for freedmen. Well, in a series of cases called the slaughterhouse cases, that came out of New Orleans, Supreme Court won't interpret the 14th Amendment that way. They will interpret the 14th Amendment to protect property rights, and that's about it. Well, that's going to fast forward us to a case called Shank versus the United States. Now, this occurs during World War I. The U.S. government had established a law called the Espionage and Sedition Act. Now, what the Espionage and Sedition Acts did was that it made it a crime, really, for you to criticize government war policy in World War I. If you were to say, look, I think the war is against the teaching of Jesus, you could go to jail. If you said, I don't think we should borrow money for the war, we should raise taxes, you could go to jail. And this was really aimed at American socialists who opposed the war. Well, one man is going to go to jail, and his name is, I believe, Charles Shank. And he is handing out pamphlets to striking miners. Or, I'm not sorry, he's handing out pamphlets to people to avoid the war, right? Don't go to the war because it can cause death and all that sort of stuff, and socialists against death. And he says, so don't even sign up for the draft. He hands out pamphlets not signing up for the draft, saying that the draft was unconstitutional. Well, that's criticizing the government's war policy, and therefore he goes to jail. Now, you would argue that that's free speech, and he's arrested by the U.S. government, and therefore the Bill of Rights applies only to the federal government, so he should get to go free. Well, that's not the way it's going to play out. The Supreme Court said that, well, there are limits on your freedom. And this comes out of the so-called clear and present danger doctrine that says that if your words or actions create a clear and present danger to the public safety, they have a right to prevent them. Sorry, I'm distracted by some sort of dog-like dinosaur attacking my luggage, my time-traveling luggage. And so, you can't yell fire in a crowded theater is the perfect example of that. You could cause damage to the public safety. You can't threaten the president's life. You can't do those kind of things. And so he goes to jail. And so it's interesting when you look back at the Shank case, he said that the Bill of Rights prohibited the draft, and he quoted really the 13th Amendment, which prevents involuntary servitude. And he argues that if you're getting drafted against your will and having to go to war against your will, that's involuntary servitude. That's a violation of the 13th Amendment. But he goes to jail. Now, in the 1920s, we had a similar case called Gitlow versus New York, and it involved a man by the name of Benjamin Gitlow, who was a communist, who later in his life became a radical right person and anti-communist. Good Lord, just make up your mind. But there was a miners' strike in New York, and he was passing out pamphlets, communist pamphlets that said, "Workers of the world unite, throw up the chains, destroy the capitalist dogs," things like that. Well, he was arrested by the state of New York, and Gitlow says, look, I know the state of New York arrested me, not the federal government, but he argues that if the Bill of Rights doesn't protect us from the states, then we really have no rights, because they can arrest us for saying things we want. And the Supreme Court says, yeah, we agree with you. And so you'd think Gitlow gets to go free, but he doesn't. He doesn't get to go free because it's a clear and present danger threat that he's making by telling these people to overthrow the government. So he does go to jail. But what the Gitlow case does, it does bring in the beginning of what we call the Selective Incorporation Doctrine, which says that that the Supreme Court's going to incorporate parts of the Bill of Rights via the 14th Amendment's due process clause on a case-by-case basis. They're going to look at the Bill of Rights and see which ones should be part of the states on a case-by-case basis. You don't want to do them all because they wouldn't all make sense. And so it begins that Selective Incorporation Doctrine. So if you're trying to sum this up, well, I was going to say if you're going to sum this up in an essay, it's not really an essay since we can't do essays right now. So now we've gotten to the point, hang on, 1 second. You can't have razors. Now we're getting to the point where they're going to look at certain cases and decide whether they apply to the states. Certain amendments they apply to the states. And we want to talk about criminal procedure. And are you going to hang on a second because I have to go stop this dinosaur from eating my luggage. Dinosaur, get away from my luggage. Oh no, it's a big dinosaur fight. It's terrible. Will I win versus the dinosaur? All I have is a toothbrush. Can the dinosaur beat me? It's a fight to the death. What's going to happen? Will I win? Oh no, the dinosaur has me in his mouth. I've got my toothbrush. Stab, stab. Oh, the dinosaur's dead. Well, that was easy. Hope no more dinosaurs pop up. So let's start looking at the different amendments. And we'll start off with the Fourth Amendment. Now, the Fourth Amendment protects you against unreasonable search and seizure. The question is, what does that mean exactly? What is an unreasonable search and seizure? Well, we debate that all the time, whether the police can come and, search your house. Can they stop you in your car? What does that mean? And what if they do that? What if they violate that? What if they have an unreasonable search and seizure? What does that mean? Now, a lot of people will say, well, they can't use that evidence against you in a court of law. Well, that's true, but that's not in the Constitution. That idea comes out of a case called Weeks versus the United States in 1925. It began the so-called Exclusionary Rule, which said that in federal cases, federal, not state, when evidence is obtained illegally by a warrantless search, then it becomes inadmissible in a federal court. So in other words, in federal courts, you couldn't use illegally seized evidence, but in state courts, you could. So that's going to go on for some time, and until about 1961, in a famous case called Matt versus Ohio. Now, in Matt versus Ohio, oh, apparently there's a dinosaur who wants to go out. Yeah, had to get that dinosaur out there. Don't ask how the chair got to the prehistoric period. I don't know how I got here. It was here when I got here. In Matt versus Ohio, somebody tried to blow up somebody who run numbers for the mob. Actually, that person ended up being Don King, the famous boxing promoter. Funny stuff. And so the police got a tip that was somebody at a house owned by Dalry Matt, and she lived there. So they knocked on the door and said, we're looking for this person, and they couldn't find this person. But she says, well, do you have a warrant? And they knock her over, wave a piece of paper in her face, and then start searching the house. Now, they don't find this guy, but they do find Dalry Matt's stash of pornography. And that was illegal in Ohio. She's apparently a lonely woman. And and she's arrested. And this goes to the case of Matt versus Ohio. And so in Matt versus Ohio, I'm going to sum it up for you. The Supreme Court ruled that the exclusionary rule applied to the states, that they cannot go into your house, anybody, and search it without a warrant. And that's not designed to protect criminals. People get mad about that, but it's designed to protect you. I have nothing illegal in my house. Not anymore. It was trash day. I don't have anything illegal in my house now. But if the police came over and said, hey, Mayor Johnson, we want to search your house, I'm going to say, do you have a warrant? Because they don't have a right to search my house, even if I don't have anything illegal, even if they could find that one brown sock I'm missing. So the she goes free, obviously. And keep in mind when you do these search procedures, and I've talked to one of my cop friends, it's like if you're going to go in there and go, look, we're going to go look for a body because we think he killed somebody. And they go, let's look in your jewelry drawer, and they find cocaine. That's not admissible because why are you looking in a little jewelry box for somebody's body? Now, if they go in and they're looking for cocaine and they open up your closet to find the cocaine and there's a body, that's admissible because that would be in plain sight. I hope that makes sense. There's been a lot of different variations under the rule over the years, depending on whether the police have acted in good faith. There's a Supreme Court case about Terry versus Ohio about pat-down searches. There's a case called Katz versus the United States, which says that you have an expectation of privacy when you're in a phone booth, that if they want to tap your phone, they have to have a warrant. Now, they don't have to have a warrant for a CB radio. And remember, this only applies to really the government. If you're at your workplace and you're looking on a computer at sites you shouldn't be, they can look and see what you're doing. They can read your emails if you're on their computer. So, stay away from doing things on their computer. So that's the Fourth Amendment. And now let's pop up over to the Sixth Amendment, and I'll explain why we make this jump here in a minute. Now, the Sixth Amendment has your right to counsel, the right to an attorney. It also has the right to a jury trial. People get that part mixed up. They think it's a jury of your peers. No, it's just an impartial jury. My peers would be all professors or political scientists. No, any of you could be on my jury if I was arrested, and I would give you 5 extra credit points if you found me innocent. All right, that's all a lot. So it also allows you to bring witnesses in your favor and to confront witnesses against you. But the big part that we really want to talk about here is the right to an attorney. And you think, well, what if you can't afford one? And you automatically think, well, one be appointed for you. Well, that wasn't the case throughout American history. It's a slow evolving right. Starting in the 1930s in the famous Scottsboro Boys case, which they've made movies about. And I think you can pick up the videos on YouTube and watch them. But there was these 9 African-American boys. They were on a train illegally. This is during the Great Depression. People jumped on trains looking for places to go work somewhere else. They got into a fight with some white teenage boys who were on the train illegally, and they threw them off the train. And keep in mind, the train's only going 20 miles an hour. They were fine. But it's radioed ahead that there was this riotous group of African-American boys on the train, and the people of Scottsboro show up with guns. It's a predominantly white town. And when the train stops, 2 white women get off the train, and they claim that they were gang raped by these 9 men. Well, this is Alabama. It's 1931. You're a black man accused of raping white women. You know you're going to get a speedy trial. It's going to take a day. They're put on trial for their lives without an attorney. A real estate attorney shows up at the last minute and tells them that they should really just go ahead and plead guilty. And they're all sentenced to death. And for Alabama, they go, look, we did it right. We didn't just hang them. We had a trial. Well, this became a cause célèbre, especially back east, and especially among the Communist Party. The Communist Party was looking for recruits out of the South. And they got a hold of this case, and they started thinking, okay, we can get down there and support these Scottsboro boys. We might be able to make inroads with African Americans into the Communist Party. And so the Communist Party hired New York City's probably most famous defensive detective outside of Clarence Darrow, Joseph Leibowitz, a Jewish attorney who'd never lost a case. So he goes down to Scottsboro and is able to get them a new trial, successfully a new trial. Now, at the new trial, they find that one, the ladies made up the story. One of them said, no, what really happened was we were with our boyfriends and we were out sleeping out by the rail yards. The other lady wouldn't stop denying it, her story was true, but when they looked it up, it was right out of a magazine. And then they brought the doctor up there, and the doctor said he saw no signs of rape from somebody who had been gang raped by 9 people, one who could not. And so they had really destroyed the story. But again, they were found guilty. And the reason they're found guilty is because it's the whole bunch of factors coming into play here. You have black men accused of raping white women. You have a Jewish New York attorney hired by the Communist Party from the North coming down there. These were things that Southerners hated. And they were found guilty again. And none of them were executed, but they're in prison for a long time. A lot of them escape. And it's not until 1977 when the Alabama will eventually pardon them, and there's only one of them left alive, and that's Clarence Norris. So a tragic case, but it established the Supreme Court had established in this case that in capital cases that you can get the death penalty, you have to give them an attorney. Now, later they'll expand that in the 1940s for those people who are mentally incompetent. I know it's amazing to think that they would put people on trial who are mentally incompetent, but they did. And then the big case that we want to talk about is Gideon versus Wainwright. Now, this was a movie too called Gideon's Trumpet with Henry Fonda. This happens in Panama City Beach, Florida. Gideon was a 3-time loser. Somebody had gone in and broke into a pool hall. They broke into the jukebox and took all the change out of it. And the police got a tip that it was Gideon. So they found Gideon in a bar. They emptied his pockets. And of course, it's full of dimes, nickels, and quarters, and they arrest him. Now, Gideon knows that he's a 3-time loser. He's about 57 years old. And if he goes to jail this time, it's for life. So he asked the judge, can I have an attorney? The judge said, well, this isn't a capital case, so no, you're not mentally challenged, so no, you don't get an attorney. And so Gideon has to defend himself by himself, obviously, with no help, and that's not going to work well. I mean, I don't know how many times you've watched Law and Order, NCIS, or any other things. You're not going to be prepared. You're going to have to go in there and defend yourself against an experienced prosecutor who's done this 100 times. And that's the way it was with Gideon. Gideon tried to defend himself. It failed miserably, and he's sent to prison. So while in prison, he studies the law and says, wait a minute, this isn't fair. You know, I should have been given an attorney because I couldn't afford one. Are we saying that we have a justice system for the poor and one for the rich? And so it went before the Supreme Court, and the Supreme Court said, yes, in serious crimes, you have to give these people an attorney. Now, you don't get an attorney when there's no prison sentence involved or ordinary roadside traffic stops. Just a heads up on that. So yes, and now we grant the right to an attorney. Not necessarily the best attorney, right? If you're Jeff Bezos, you probably could hire the best attorney if you commit a crime. If you're Brian Johnson, you're probably getting a public defender who thinks that you're guilty. So that's the Sixth Amendment. Now let's go to the Fifth Amendment. Now the Fifth Amendment has a lot of parts to it. There's double jeopardy, but then the one we want to talk about is the right against self-incrimination. The one you know as I plead the Fifth, right? Now, this was originally applied to the states in a case called Malloy versus Hogan. The Supreme Court said that the right of self-incrimination applied to the states. It was a case of gamblers, and Malloy was called to the stand, and he wasn't on trial. He was a witness, and they asked him, are you involved in these illegal gambling activities? He goes, well, I don't want to answer that because it might incriminate me. And the judge says, well, either you answer it or I'm going to send you to jail for contempt of court. So Malloy's choices was, well, okay, if I answer, I go to jail. If I don't answer, I go to jail. And he didn't answer, so he went to jail. And so it appealed to the U.S. Supreme Court, and they said, no, You can't do that. He has the right to self-incriminate and not to self-incriminate himself. Now, the big case here is going to be Miranda versus Arizona in 1965. A little backdrop about Miranda. There was a young girl who was picked up outside of a movie theater by one Ernesto Miranda, and she was raped. And Miranda then dropped her off at her house, and she picked him up out of a police lineup, give a description, picked him out of a police lineup. And then they did a medical examination of him, and they found that he had an illness of the schizophrenic type, and he had an education of 8th grade. And so they talked to him for 2 hours. They don't threaten him, according to Miranda. They don't coerce him in any way, according to Miranda. But after 2 hours, he ends up pleading guilty. He says, I'm guilty. And he's sent out to life in prison. Well, once he got to prison, he started thinking, wait a minute, I didn't know I had the right to remain silent. No one told me that. I didn't know I had the right to an attorney. No one told me that either. And they should have told me that before I started talking. And so the Supreme Court said in Miranda versus Arizona, you're right. You have to start issuing what we now call your Miranda warnings that you're all aware of if you watch any TV. As for Miranda, he was later stabbed to death in a bar, and his assailant got away. Well, they arrested his assailant, read him his Miranda rights, and then the guy got away. So an irony for Miranda that he had, after he was killed, his murderer was read his Miranda rights. Now, the Miranda rights don't apply in case of ordinary roadside traffic stops. So you can't, read me my rights if you pull the stop sign. And they can delay reading your rights if there's a threat to the public safety. So just read a note of that. So let's bring us up to one more amendment here, and that's the 8th Amendment, and that protects you from cruel and unusual punishment, like these videos. And specifically the death penalty. Now, in 1973, in the case of Furman versus Georgia, the Supreme Court declared all existing death penalty cases to be unconstitutional. They said the violation of the Constitution's cruel and unusual punishment clause in Amendment 8. And they said it was cruel and unusual because of the way it was being applied. And I don't mean being applied by gas chambers or bullets or anything, because those things still exist. They said it was being applied arbitrarily, mainly to poor people and minorities. And so everybody who was on death row at the time had their sentences commuted to life. Sorry, I have to let Dinosaur in real fast. Yeah, so, and this included people like Charlie Manson, that famous killer, Helter Skelter. It included Sirhan Sirhan, the man who killed Robert F. Kennedy, a lot of people. And the reason that they didn't just retry them is that because you lose a lot of the evidence after a while. People die, witnesses die, evidence is lost, and so they just commuted to life in prison. And so I think Sirhan's still alive. Of course, what's his name? Charlie Manson died recently. And I'm going to throw this Kleenex into the volcano. All right. So, but we have a death penalty today. And so what the Supreme Court did was they set up the conditions under which you could have the death penalty. And that was in Gregg versus Georgia in 1976. What they said was that if you're going to have a death penalty, you have to write the crimes into law for which you can get the death penalty. You just can't arbitrarily say, okay, well, this time we'll give them the death penalty, next time we won't. It's got to be written down. It's got to be in statute. And in Texas, we have done that. In Texas, we have the death penalty for murder while committed a felony, like aggravated sexual assault, aggravated assault on robbery, things like that, while you're committing felony, while you're committing a murder of a police officer or firefighter in the line of duty, murder while escaping from a prison, murder for hire, and murder of a child under the age of, I think it's 7 now, and then serial murder. He killed Snap, Crackle, and Pop. Serial murder. And they also said that if you were going to execute somebody, you'd have to have a 2-stage trial. The first stage is that you have to convict them, obviously, beyond a reasonable doubt. And the second stage is the punishment phase. What punishment do they deserve? You can't have a mandatory death penalty because somebody might have just slipped out at the moment they'd been nonviolent their whole life and committed this murder. Doesn't mean you don't go to prison, but maybe you don't get the death penalty, and that's up to the jury. Were there mitigating circumstances that made you decide to kill somebody? Dog. So, and last but not least, the other case that we're going to deal with is the wrestling, in case you're wondering. Coker versus Georgia. A lot of Coker cases here. In Coker versus Georgia, the Supreme Court pretty much said death for death. That if you're going to kill somebody, if you're going to execute somebody, it has to be held up for the most serious crime. The most serious crime is murder, because you've taken a life and that cannot be restored and they cannot recover from that. So when people say they want the death penalty for, child molesters, the Supreme Court said no, it's got to be death for death. Hello, dinosaurs. I am trying to. Oh my gosh, they've thrown out the illusion of my whole illusion here of being in front of a dinosaur. Illusion completed. So, yeah, it's got to be death for death. So that's the death penalty. It's still controversial. Many states are abandoning it because it's just too expensive because of the appeals process. And if you think you want to limit the appeals, there is a problem with that. That you limit the appeals, you are more likely to execute innocent people. And there's a lot of studies that show that it's not the severity of the punishment that deters people; it's the surety. And so I think that you're eventually probably going to see the death penalty die out in the United States, mainly for financial reasons and the possibility that you may execute an innocent person. So next time, what we're going to talk about is freedom of expression, and that should be fun, I think. So I'll probably do that tomorrow. So until then, I'm going to time travel out of here because that volcano looks scary.